Okay. Well, it is the 29th of April, and welcome to week 4. We are now officially starting our second half of the course. Um, and so I am going to mention this again later, but I'll mention it now that any assignments from weeks 1 to 3 that have not been submitted by Sunday, by the end of Sunday, will not be accepted, because then we will be starting week 5. And I'm going to talk about um, some of the assignments that I have graded. Like week 2, I graded yesterday, and some students did not get my message about citations in the body, and many provided references, and some didn't provide any references for that week 2 assignment. But I said before that you need to follow the rubric and the far right. We're going to go into that in just a minute. So I'm going to share my screen. Excuse me. Okay. So we're going to come down here, and you'll see that we have actually 2 more lectures, not 3 more. This is week 4. So guess what? We got 1 more lecture, and that's next week. That's right, week 6, there is no lecture. I forgot about that in this class, the way they set it up. So let me remind each of you, and you know your live lecture recording, you got an extension on that to Mondays because of the, instead of Saturday, or Sunday rather. So let's take a look at week 4 announcement. Here we are. So this week, we're going to talk about prisoner rights and evolution of probation, what probation is about. And then I previously sent you the PowerPoints for chapters 8 and 9 of American Corrections, the textbook, along with the other activities. So today we're going to look a little bit at the law of corrections and prisoner rights, Bill of Rights and community supervision, corrections, law and prisoner rights activity, sentencing sanctions, vocabulary review, evolving role of the probation officer. What is the role that the probation officer plays? Your discussion posts, initial posts were due last night at 11:59 p.m. Central Standard Time for intermediate sanctions, and your reply posts are due Saturday at 11:59 p.m. Central Standard Time. Finally, you're going to complete uh, the written assignment, probation officer, and then you also have the quiz. And I've told you before how to deal with the quiz each week. Use the PowerPoint and the material that I send you and the stuff we talk about in the lectures to prepare you to get ready for it. And then there's a mid-quarter student survey. If you could take the time to complete that, that would be great. And then you know about adversity as a springboard to success. It is very interesting that that's my motto, because we are all in an adverse situations. And so I've been getting messages from various students that the effect of COVID-19 it has had on individual students. I had a few, and then I have some that they're family members as well. And then you know what I'm dealing with right now. So anyway, we just keep pressing on. I'm holding on. So thanks for being patient with me getting these grades out for you. And, I'm going to be working on week 3 this weekend to get those out for you as well. Not Sunday. I'm not doing any grading Sunday because Sunday is May 3rd. That's when your assignments are due for week 4. And that's the day that I celebrate my 70th. So I will not be doing any of that. So let's look at the course calendar real quick. And here's where we are here for our live lecture. And then, so that was week 1, week 2, week 3. This is week 4. And so week 5 will be next week, the last one, May 6th. All right. Oh, okay. All right, no problem. On call. Okay. If not, then you can just look at the recording. So I understand. I know you got to do what you got to do, and that's what you're paid to do. So no problem there. So the live lecture, and then your reply post the second, and then your written assignment is due uh, the 3rd, and due on the 3rd, and then that's the same one, and then your quiz. There you go. Will be due. Then of course, your key phrase is now due on midnight on Monday the 4th. Okay. So anyway, that's what we have. So let's take a look at the assignments for the week. Okay, so your discussion um, involves intermediate sanctions. All right, and so you're going to look at this scenario, and then uh, in your initial post, explain an intermediate sanction that for Pat's violation, and then support the sanction, explaining why you selected it, and then your response post, choose a peer with a different sanction and respond to that. Okay. Your written assignment, probation officer, and it tells you a scenario, and you're going to use this scenario. Create a job announcement for a probation officer position that includes and summarizes the duties, describe the 4 roles of a probation officer, include specific examples of what the probation officer is required to do in fulfilling these roles. And there they are: surveillance, broker service, liaison, court, change agents, intervention. And then, again, I keep saying, provide supporting evidence for credible sources. Now, I'm going to go ahead and pull up the rubric. Let's look at the rubric. I have spoken about this. I said, if you do not have credible resources in the paper, that's citations, and don't just throw 1 or 2, and also make sure you don't just use the textbook, and don't just use the stuff in the module. I want you to do research. I've said that from the very beginning, and it's very important that you do that research. And notice what happens when some of you in week 2, you could not get past emerging. In order to get past emerging, you had to have, notice this, it says missing credible resources, evidence from credible resources. That leaves you with this in all aspects of it, all the way down, until you get to the spelling. Usually most of you get 5 there. But down here, you lose 9 points here. lose 9 points here. You lose 7 points here. All right. So you lose all of those points. 9 and 9, 18, and 25 points. 25 points you lose because you don't have citations. I said that before, and people missed it. Notice though, even if you have citations though, you're still going to have more information. Remember I said, forget about these 3 columns. Focus on mastery. And this is what your goal is. A summary of the continuum of probation officer duties, thoroughly supporting evidence from credible sources. References are not credible sources. They are the place where you got credible sources, but within the body of the paper where you got statements and information that you included in your actual written assignment, whether it's a brochure, whether it's a plan of action, whatever it is, you need to support it with the information and sources that you got it from using APA citations. Very important. All the way down, notice it says credible resources, credible resources. But you notice here, these first 3, missing supporting evidence from credible resources. So if I don't see any credible resources, then you're going to end up with this, with the points that you can get from here. So you might end up with 8, 22 and 8. That's 30. And then you might get 5 here. 35 points out of a possible 60 points. You don't want that. And that's what you got to remember. I said it before, and you got to pay attention. Make sure that you understand credible resources, credible sources in the paper, not the references. I said it before, and I'm saying it again. And let's see what happens with people who do, excuse me, this assignment. Since I haven't graded week 3, I don't know how week 3 is going to be, but it's the same thing. So if you take a look at, just for a minute, I want to just show you something. I'm going back to show you week 2. I got to do it because it hasn't been different. Week 1 was the only one I wasn't really that adamant about it. But look at this. Look at the rubric. I just want to show you how the rubric is very consistent. Notice this. Many people got this because they didn't have any credible sources. So I couldn't put you in and change any of these because you stayed in the same column all the way down till you got to spelling and grammar. So one of the common grades that people got is 20, 31, and 5. So we got 36s. And the reason is because you didn't have any, and I gave you the 5s from spelling and grammar because most of you did pretty good there. But you gotta get those credible sources. You have to. You need a cover sheet and you need a reference page. I said that before. So that's it. So it's not, you're not caught by surprise with any of that. The same thing with week 3. I'm just spending time right now trying to help you so you can do better in the second half. Same thing. If you don't have credible sources, see credible sources over here, each of them, you got to have them. Missing details on the specific elements of each type from credible sources, you end up down here and your grade's not so good. The more credible sources you have and information that you provide, the closer you get to this. I think I got 20, I think it's 25 or 26 students in this class. Um, and I think I handed out maybe 10 perfect scores because people had these resources over here using this. So, does everybody got that? Everybody got where I'm coming from? Uh, yeah, I graded your week two. You haven't seen your week two grade? Oh, okay. No, well, week three, yeah, week three is it just completed Sunday. So I'm working on that, and that's really not technically due until Friday, but I'm going to be working on that. So, yeah, but no, week one, I'm talking about week two, and that's what I'm reminding everybody. So, I mean, everybody's got the fact of what I'm saying, though, how you can get a better grade. Well, that's fine. Okay, everybody got it? Okay, make sure. Very, very, very important. I said this before in lecture two, and I said in one I wasn't going to be so tough on it. But in week two and week three that you just completed, and in week four that you have yet to do. All right, let's go back to four. So now, with week four, you know what to do in terms of your assignment. Week four quiz, you got 3 shots at it. So make sure you get it done. Uh, there are some students who still have not done their quiz from week three. It is late now, and if a student does it, you're going to probably lose points when you get it done. But the point of the matter is that you got 3 shots in a week, so there's no reason why you can't. And then make sure what you messed up on. And like I said, you're not supposed to be taking notes when you take the quiz. I'm telling you, don't do that. That's a violation of the academic misconduct policy. Okay. And then your live phrase that I give you, or word that I will give you at the end. Any questions about the assignments for week four? Guess not. I don't see any. Okay. Um, let me see what you said. Uh, Yeah, until they take the header away, you should always. But I'm not a professor who really has penalized too much students with the header. But yeah, it until they take it away, then yeah. All right. Any other questions? Everybody's all good? All right. So now let's talk about the topics here. So we're going to just touch on some of these things: the Law of Corrections and Prisoner Rights, Bill of Rights, and Community Supervision, Corrections Law, and Prisoner Rights Activity, sentencing and sanctions, and then the evolving role of the probation officer, and then a little vocabulary review real quick for you. So the the rights of prisoners as is founded on 4 aspects. First of all, the United States Constitution, which sets out the the supreme laws of the land, and that the Bill of Rights is primarily what sets it out. And so the federal government, which has, as you already know, three branches: the legislative, which is Congress, which consists of 435 people. And then there is the Senate, which is 100. And then there's an at-large senator. And then the executive branch, which is the President of the United States. And then the United States Supreme Court is the federal branch. So the laws are actually passed by Congress, enforced by the supposedly by the president, and then interpreted by the Supreme Court. So what the Supreme Court will do is determine what the law is and whether or not it satisfies the requirements of the United States Constitution. And there are various statutes that are passed by uh, the, um, the states, as well as the federal level and local levels as well. All statutes that are passed in the United States are in what we call the United States Code, USC, and there are different sections of it depending on what area that's involved. Uh, every state has some legislative branches the same as indicated on the federal level, except the legislative branches consist of the House and the Senate, and then the executive is usually the governor in the state. And then your highest court that you have is the Supreme Court in states. So there are individual state Supreme Courts, not to be confused with the United States Supreme Court. And so there are cases that are decided, as I said, by the judges. They base upon what we call precedents. Precedents. And what a precedent is prior decisions that are issued that help make up our law. And we operate on a Latin phrase called stare decisis. And what that means is previous decisions will give guidance to future decisions. Now, there are times when um, past decisions are reversed. And the reason they're reversed is because someone comes up and presents to the courts a good reason why the law should be changed, such as separate but equal when the Plessy versus Ferguson, the United States Supreme Court case. And then in 1954, separate but equal was done away with the Brown versus the Board of Education, which allowed individuals to start out with the civil rights laws that came after that, which were statutes passed by the Congress of the United States, and they were presented to the Supreme Court, and then they were interpreted by that all levels of the courts. Then there are regulations. These are guidelines for what we call administrative agencies, such as the Environmental Protection Act, the Department of Prisons, and other agencies. And they're usually set up through the governor if it's the state, president if it's the United States, to implement the policies that the agencies operate under. And so again, remember the Bill of Rights is something for the citizens, to help the citizens to be protected. And that notice what has happened is that the Bill of Rights was applied to the states with the 14th Amendment, where it barred states and other local jurisdictions from violating the rights to due process and equal protection of individuals. Prior to the 14th Amendment, then the only way the Bill of Rights applied was in federal law. not in state law. But thank God now it is applied in state law as well. When you take my constitutional law class, which I teach, I break that down into a lot of detail. So I'm just kind of going over it right now. So there are a lot of rulings that the courts go up and down, back and forth, and that's what we lawyers have been doing. Right now, I'm taking a course uh, online from my alma mater, Northwestern University School of Law, involving COVID-19 and the various aspects of the law, and dealing with civil liberties, dealing with how it affects the criminal justice system, how it affects inmates, and so forth. So we're covering all of that stuff. But the point of the matter is that we're dealing with the Bill of Rights. We're dealing with the 14th Amendment application to the states. So as it says here, before the 60s, the courts didn't interfere too much with due process in corrections because of the fact they felt that that should be something to be handled internally for individuals who have been uh, deemed to be people who made mistakes and are serving time, or I hate to use the word, but I'll use it, um, being punished or taught things that they must do. So the courts kind of started uh, in the 60s to apply uh, the law of the various jurisdictions. And it says some states use their constitution to correct abuses in jails and prisons, followed by the belief that incarcerated individuals forfeit all rights. Well, we know that's not true anymore. People are now given the right to vote, which I think should have taken place before. Uh, People are given the right to worship, the right to obtain an education, which all those different kinds of things. The rights to um, decent um, housing while they're incarcerated as well. And when you run into problems with that, then there are what we call 1981 suits. That is a section under the United States Code that comes from the federal court and is not a state issue, but is a federal issue that is derived from legislation that has been passed and applying the United States Supreme Court Bill of Rights as well. Okay, so just a few of these things here. So dealing with the First Amendment, and it talks about really religion and exercise and the freedom of the press and speech and to assemble and petition. So the point of the matter is that, and notice what has happened here. In 1962, this is stuff that has happened in correction facilities. So in 1962, the Muslim faith was recognized. Prior to that, the only ones that were recognized were the Christians and maybe the Buddhists and the Jews. So Catholicism as well. In 1974, censorship of the mail is permitted to maintain prison security so that things can't come in the mail without them checking the mail. Did you not know that all mail that goes into prisons is subjected to being open and reviewed for a number of reasons? One of the reasons is not just because of the information in there, but because also they want to make sure there are no drugs. They want to make sure there are no weapons in there as well. In 1987, the rights of Muslims are not violated when work makes it impossible for them to attend religious services if no alternative exists. So there are various cases that have decided these. in 87, incarcerated individuals didn't have the right to receive mail from one another, and this mail could be banned if regulated to protect the prison. So there were issues that ended up in court that caused decisions to come out. So this is First Amendment stuff. So basically, uh, yeah, yep, yep. As I said that earlier, that all mail is open regardless because of the reasons of security. And then also, prison policies in 2006 that deny magazines, newspapers to the most incorrigible residents in an effort to promote security and rule complaints. You'll be surprised. Let me tell you what happened here. I represented a corrections officer at the county level, and he got in trouble because of the fact. What did you say? Let me see what you just said a few minutes ago. Oh, no, you can't go through legal mail. That's correct. Yeah, legal mail. Yeah, well, that's because of violation of the attorney-client privilege. But absolutely, absolutely correct. But what I was going to say about magazines and things of that nature, I represented a guy who did a favor for an inmate and brought in some magazines. And uh, it turns out that there was a problem with the magazines. Anybody have a clue about what the problems were with the magazines? Okay, let's see what Wright said. Oh, okay. Yeah. Well, it's not just women, children, and half nudity. Nope, that wasn't the problem with this mail. What do you think another problem could be? Any other ideas? Anybody have an idea about how you can smuggle drugs using magazines, newspapers, and photographs? Anybody know? Yes, and yeah, but that's not the one. Okay, wait a minute. I think I saw something close to it. He said, and cover it with a cover, spray, melt it, melt it, melt it to it. I don't quite get that one. What do you mean by that? I'll tell you what the problem was. The magazines, which were sports magazines, so they were a problem, had been soaked in PCP liquid and dried and ironed out. So when the inmate got the magazine, do you think he read it? What do you think he did with it? Any guesses? He chewed the pages and could get high from what was soaked in the paper. And that was a problem. That was a problem there. So there are all kinds of things, but some of the things you guys said are true. But the one I was referring to was the case that I had. Yeah, and my guy didn't know that. He didn't know. He thought he was just doing a favor, but he ended up uh, getting a problem with his job. So that was the First Amendment. Those are First Amendment. Now, the Fourth Amendment deals with searches and seizures. If you take my constitutional law course, we talk about the Fourth Amendment quite a bit and talking about warrants issuing, but on probable cause and so forth. So here we go with Fourth Amendment decisions. Conversations recorded in jail's visitor room are not protected by the Fourth Amendment. Now, except you can't do that with who? Who can't you do it with? That's right. You can't do it with legal. And that's because of the attorney-client privilege. Very protective. Um, so the conversations recorded in a prison, in a jail visitor's room, or medical, that's another one, are not protected. So everybody in that room should know any conversations they have, they're being recorded. Since 72, a warrantless search of a cell is not unreasonable, and evidence found that there is not subject to suppression in court. It is not reasonable to expect a prison cell to be accorded the same level of privacy as a home or automobile. Why? Because it is a place where you're trying to maintain control. And so the same rules of Fourth Amendment are relaxed in those situations because searches are done at random. Strip searches, including searches of body cavities after contact visits, are carried out when the need for searches outweigh the personal rights invaded because of weapons and things of that nature. I mean, you'd be surprised at some of the things that I've heard some of my students who have been correction officers that share deal with these searches. In 1984, officials may search cells without a warrant and seize the materials found there as well. So the key thing is that your Fourth Amendment rights are, should I say, not taken away, but the government has more rights there. So now we deal with the Eighth Amendment, and that is, it says excessive bail should not be required, nor fines imposed, nor cruel and unusual punishment. Most of the things that we deal with here with prisons don't involve excessive bail or fines, but cruel and unusual punishment. So in 1976, a case decided that deliberate indifference to medical needs constitutes unnecessary and wanton infliction of pain and violates the Eighth Amendment because it's cruel. And so the key thing is that the inmates have a right to medical attention for illnesses, which is why this whole issue about COVID-19, and I can't wait for us to get to our week that we're going to be studying now. I think that's week 3. We just started week 1 this week. And so so it's a 4-week course that I'm taking there. So I'm in school like you guys are. And so the key thing is to provide medical care to protect individuals, and in situations like with COVID-19, I can tell you already that it fits in the mode of recognizing, because we're in a pandemic situation, not to let people out, but to try to do everything possible to provide the medical care for those individuals for a number of reasons. Number one, they can spread it and have spread it among individuals. There have been correction officers. My daughter works as a psychologist in county jail, Cook County Jail, and so she has to go through all kinds of steps and wear all kinds of stuff when she goes to work. In 1980, conditions of confinement in the Texas prison system are unconstitutional, again, because inhumane. 81, double selling and crowding is not cruel and unusual punishment. In other words, someone tried to bring a case saying that it is unfair for them to share in a cell with somebody else. They felt like they should have their own. And so in order to deal with this, it says it must be shown that the conditions involve wanton and unnecessary infliction of pain and are grossly disproportionate to severity of the crime warranting imprisonment. So basically, the burden is very high that the inmate has to prove to have a individual cell. And I'm not talking about uh, when you deal with the issue of let's see, what did you say here? Yeah, yeah. Oh, okay, ate the paper. Yep. Okay. Some people I see had it here. Going to work every morning, we get drilled by fever check. Oh yeah, yeah, yeah. That's because, um, yep, yeah, yep. And that goes into all areas as well, not just in prisons. So in '86, a prison resident mistakenly shot in the leg during the disturbance. They don't suffer cruel and unusual punishment if the action was taken in good faith to maintain discipline. So what they're trying to argue in this case is that the uh, facility should have protected the individual from that kind of activity. 1991, plaintiffs must not only prove that prison conditions are objectively cruel and unusual, but also show that they exist because of deliberate indifference of officials. So it's the hard burdens that are placed on the inmates to prove that there's a cruel and unusual situation. They use that phrase loosely, and that is the prisoners. In 2003, regulation suspending visiting privileges for 2 years for those who flunk two drug tests don't constitute because somehow or another, what's happening is that they're either getting the drugs inside the facility, which is very plausible, or either someone is getting it into them as well. Definitely. Even an innocent pack of gum can create that situation. And so the 14th Amendment that talks about the states, it says, and dealing with the states now, dealing with cases that going all the way from 68 to even now, but 95 here, a few of them. The law in Alabama that was used to segregate white from black individuals is unconstitutional. And that uh, is because of the fact that at one point they were doing that, but that shouldn't take place. The basic elements of procedure and due process must be present. In other words, you have a right to uh, uh, confront. What did you say? You disagree with what? Nope, nope. You should not segregate whites from black individuals in prison. That is a bad move. And the reason why it is a bad move is, well, security can happen. It's not a race issue. That is a bad decision to do that. It is not based on the race of the individual. It's based on the tenacity of the individual, regardless of the gangs. There are white gangs, there are black gangs. You might segregate gangs, but not races. That's not good. That is a bad move. You'll never hear me uh, do that. But gangs, it's hard to separate them because of the facilities. You don't have enough space to take those individuals and put them in separate uh, uh, facilities and separate sections. You might do so, but once again, you don't you don't have the ability to be able to uh, deal with that in terms of gangs. You find out about it, so it's not unconstitutional or illegal to separate individuals who are known members of certain gangs from being placed in groups with another gang. Okay. So anyway, I stand on what I said. It says you cannot segregate people on the basis of race in jails or prison. That's a bad move. All right. 1974, the basic elements of procedural due process must be present when decisions are made concerning the disciplining of an individual who is in prison. So the 14th Amendment says that you have an opportunity to respond, you have an opportunity to face your accusers, and you're not, as they say, railroaded, um, not directly, but you have a right to counsel, to represent you, and to receive the evidence. 76, although due process must be accorded, an individual has no right to counsel in a disciplinary hearing. That decision from 76 is under attack and has been under attack for many years for dealing with the right to counsel in disciplinary hearings. And that's an old decision that goes back to when I was in law school. Says because there's argument has been made that the Sixth Amendment, whenever there is a chance that a person can receive more time or something of that nature, then there is an absolute Sixth Amendment right to um, counsel. 1980, the involuntary transfer of an incarcerated individual to a mental hospital requires a hearing. That's due process once again, and the ability to have counsel to represent them. In 1995, prison regulators don't violate due process unless they place something that's atypical and significant hardships on a resident. It appears as if they may be picking on that individual. So if you notice the list that is here, it gives individuals an opportunity to be treated humane, but it also, at the same time, balances the loss of some of the rights in favor of protecting those who are in the facility. Because it says when it comes to constitutional rights, community supervision encompasses both those on probation and parole. Okay. So the statement by a Supreme Court Justice, the late Anthony Scalia, explained the constitutional rights of probationers and parolees is always true of probationers um, and parolees, that they do not enjoy absolute liberty to which every citizen is entitled, but only conditional liberty dependent upon certain kinds of restrictions. And so the key thing is that when you're incarcerated, your rights are going to be pushed back. Any questions? Okay. So now let's look at the Bill of Rights and community supervision. So there are a number of cases, and I'm not going to go through all of these cases, but just a few. Griffith versus Wisconsin, 87, deals with the warrantless search of the petitioner's residence, that is, that maybe their cell was reasonable because of the conducted response uh, to a regulation that in itself is a reasonable response to a special need of probation system. The key thing is that be aware, is as I said earlier, that warrantless searches are allowed in prisons, period, for the protection of everybody. Pennsylvania versus the Board of Probation and Parole versus Scott. It's a 1998 case. It says evidence would be barred by the exclusionary rule from the use by the prosecution in a criminal trial can be used in parole revocation hearings. In other words, there's evidence that is in violation of the Fourth Amendment that is used by, that cannot be used in a court of law. but in criminal trials, but it can be used in the parole revocation hearings. Does anybody know why that is? It has to do with the standard of proof. Do you know what the standard of proof in criminal cases is? Anybody? Beyond a reasonable doubt. You've heard that before. Guilty beyond a reasonable doubt. And in parole revocation hearings, it is preponderance of the evidence, which is like 50-50. Okay, but the you can't use that in probation and parole hearings. Okay, that's why the exclusionary rule is not there. A probationer has the right to counsel in a revocation hearing before a sentence is imposed. All right. Morrissey versus Brewer. I remember this extremely well from law school. And this basically explains what takes place, where a hearing officer has to determine if there's probable cause that a violation occurred, and then the parolee has a right to, as I said a minute ago, be notified of charge against them, know the evidence, speak on their behalf, present witnesses, confront the witnesses themselves. At the revocation hearing, notice of the charges is given so that they can have a chance to prepare a defense to those charges. That's basic due process. Gagnon versus Scarpelli, the rights established under Morrissey versus Brewer that I just gave you apply to probationers. Right to counsel should be granted on a case by case depending on how difficult the issues are, mitigating circumstances, and the competence of the individual. So if the individual, some individuals are very sophisticated and they can do very well, but generally most individuals don't rise to that level, even those so-called jailhouse lawyers. And then 1983, I was talking about those earlier, uh, means that incarcerated individuals can bring lawsuits against correction officials for violations of religion or violations of other civil rights. And it applies not only to incarcerated individuals, but those also on probation and parole. And there we go back to it. So dealing with corrections law and prisoner right activities, um, you can go through these yourself, but you can find out very quickly here by going through a quiz. And it talks about going through it. And I recommend you go through this and match these items. So let me see what you just said. Okay, let me go down here. Okay, we already addressed that. Okay, gangs, we already talked about that. Okay, religion is a big issue here. I think you said that you're right, just an opinion. Okay. Because so many intermingle and we don't have the staff to keep up with all the offenders that need to go to worship. Okay. Well, again, there are some restrictions that you cannot do, but it depends on the present circumstances. Like, for example, right now, there are people who can't worship in the groups that they used to be able to worship in prisons the same way people outside are not, because of not the beliefs, but because of the number of people in an area. So, all right. So moving right along, match a couple of these. The 14th Amendment. Which one does it apply to? All rights, or rights related to bail. Okay, let's see. Okay, we put it there. Rights related to search and seizure. So I was right there. Rights to freedom of speech, religion, and that's there. And then punishment, submit, and these are all correct. Okay. I don't know what you're saying here. I'm trying to get. Well, I don't know. It might be your. Does everybody hear me? Is anybody having trouble hearing me? Can everybody hear me? Yeah. Yeah. It's sometimes it's your Wi-Fi, and that's what I tell students. So you just end up having to, listen to it. But yeah, it's the Wi-Fi. All right. So anyway, you go through those. You go through those. Okay. I don't know about that read lip stuff, but anyway. So corrections, right? Activities, you go through that. And then dealing with the various sentences and sanctions, from fines to jail. Um, you deal with fines and restitution. This is getting into the intermediate stuff. Community service work, drug and alcohol treatment, day reporting, drug controls, home confinement, shock incarceration, and boot camp. And these are just some of the things that you deal with when you start to get in the intermediate sanctions. Continuation, these are some more under here as well. I won't go through. There's a whole list of them there. So now let's talk about the probation officer for just a minute or so. We're almost out of time. We are. Um, Probation officers, first of all, number one, you cannot be a probation officer unless you have a bachelor's degree. It is not possible to have a high school diploma and be a probation officer anywhere that I know, or either whether it's state, federal, local, or county. And so, okay, okay. Well, like I said, I knew you might have to go, so you had indicated, so no problem. Now, the probation officer's roles is to make sure that they work with the probationer. And actually, you know, it'll be a situation where the probation officer has the responsibility of making sure that the individual satisfies um, the rules and procedures that the court issues uh, for probation. And parole is when the parole board or the agency issues rules. And so they have the responsibility of going on and dealing with these duties here, working and helping individuals through their home employment, um, dealing with PSI investigations. A PSI investigation is when, in a probation situation, when an individual is being sentenced, they conduct an investigation to know the criminal history of individuals, um, to report violations to the court, transfer investigations, moving from one jurisdiction to another. In other words, taking a person from one jurisdiction to another. Uh, Pre-release investigations. Now that's when you get to prison and you're dealing with that with parole, and then dealing with court appearances and testimony. And that's another role that the probation officer, parole officer does, but probation officers do it a lot. By 1996, they added more things. Um, Progress reports, bail evacuations, sentencing guideline worksheets, conditions for what the individual is released on to make sure they're satisfied, program monitoring, community service, and dealing with whether or not there's a gambling problem. Notice what you're seeing is that moving all the way up, the probation officer picks up more and more responsibilities. These are common things now that based upon what's happening in the courts as of 2009, dealing with restitution, victim impact statements, determining sex offenders, DNA testing, which never existed when I was practicing, violence assessment, risk, dealing with drug use, alcohol use, um, and the case, it goes on and on and on. Electronic monitoring is a big one, and dealing with diversion programming. Now, you deal with annual assessments. You have all of these different things. And if you pay attention to what is taking place, the probation officer is more of a social worker now than ever before, and making sure that inmates are moving in the right direction. Okay. And so today, probation officer is often referred to as a change agent, um, because the probation officer is not only responsible for enhancing public safety, but also for working individual with the offenders to help them with skills and help them to get their lives back in order, back on track, so they can become citizens that contribute a positive role. And so these are just some of the things here. You know about that from your assignment. And so I'm going to tell you to make sure you go through this vocabulary review. Take a look at a couple of them here. These quizzes are good, where you can match the items with the description. So what's a hands-off policy? The first one, the second one, the top, the bottom, or the middle? What's hands off? Anybody guess? What's a hands off policy? Reading what's on the right, matching up with what's on the left. Any guesses? Okay. A judicial policy of non-interference. Yep. And the next one, the constitutional guarantee that no agent will use any procedures other than those described by law. Yep. and then case law. And this should all be perfect. Yep. So you can continue doing that. And I recommend going through those that I just showed you before you take the quiz. Tick, I'm giving you hint, hint. Did it before, and some of you got it and some of you didn't. Okay. All right. And that's it. Any questions? Okay. So now, any ideas? Let me put the chat up back up. I need to put the chat. Okay, let's go back. Okay, let's get rid of that. I don't know what happened to my chat box. Oh, I know. Let's hit on this. Okay. So anyway, anybody have any clues about what the possible phrase would be? You said the role of probation officer. Is that what you said? That's your guess? Any others? That's that's it. You were close, Rice. It's probation officer. That's it. That is it. When you said role of probation officer, you were real warm. But yes, it's probation officer. All right. Yeah. Well, stay safe out there while doing the job that you have to do. And so um, everybody else stay safe as well. I'm going to go and do some stuff I need to do. And then again, I'll see you guys next Wednesday. All right. So I will be um, probably not so focused on next Wednesday because my brother-in-law's service is Tuesday night, Tuesday afternoon. So that Wednesday. But anyway, uh, just keep me in your prayers as well in dealing with this situation. And those of you who, thank you, who are dealing in situations, keep yourselves focused and recognizing that during this time, I'm very flexible in terms of dealing with my students. I try to work hard with you. Again, feel free to reach out to me anytime you need me. Okay, so I'm going to say good night at this time. There was a story about one of your students. Well, I don't get that one. There was a story about one of your students. Oh, on graduation? Oh, really? Uh, on graduation. Okay. Oh. Well, the story about my student is that my student had some troubles and challenges in this class when it was an 11-week class, and then he took another class with me, and he ended up being one that I could mentor. And so I mentored him. I took him on to mentor him, and he started getting uh, on the dean's list. We went back and forth, back and forth, back and forth, and we found ourselves in a situation where I had to end up um, finally helping him in a heavy fashion. So yeah. So anyway, the long story short was I showed up at his graduation last June, surprised him by going to his graduation. So I have a tendency to do stuff like that sometimes with my students. That's kind of like the short of the story. So the kids that I nanny for have been living with me because their parents, oh God, definitely keep that in prayer. So, all right, guys, I'm going to say good night to you and see you next week with our final, remember, that's our final lecture next week. Good night.